Welcome and good morning, everyone. Good morning. I'm Stephen Simon. I'm with the Raven Group. I am simply honored to have the opportunity to support Californians for Safety and Justice in making today happen. This state has been talking about realignment and criminal justice reform a lot this last year or so. And quite frankly, there have been a lot of panels on it. There have been talking heads on it. This group that's sitting in front of you today are a lot of the folks that are really hands-on with making the policy changes, making the decisions that are going to make a difference about what criminal justice looks like in Los Angeles County over the next decades. So we're very excited to be part of today's event. My job is simple. It's to say welcome to the University of Southern California, and it's to introduce your moderator. And let me tell you, it's tough to figure out who would be moderator because Miriam is one of those people who just needs to be on this panel as well. That said, Miriam Krinsky, 15 years as federal prosecutor, assistant United States attorney in the Central District of California, executive director of the Children's Law Center of Los Angeles. But most people in this room probably know her from her incredibly steady hand as the executive director of the Los Angeles County Citizens Commission on Jail Violence, having to look at some extremely difficult issues and come up with some really practical and clear solutions to those problems. That's the kind of discussion we'd like to have today. So without further ado, thank you again for joining us, and please welcome Miriam Krinsky.
So thank you, Stephen, and thank you to the Raven Group for, as always, organizing a wonderful event and what I know will be a very hearty and substantive conversation. I want to thank Californians for Safety and Justice as well for being a partner in pulling this together and for the tremendously innovative and insightful work that Lenore and others of her colleagues are doing. And despite the fact that I'm a double Bruin, teach at UCLA, and was married on campus at UCLA, I do want to thank Supervisor, I know you're here to counter that. You will have a right of rebuttal, but I do want to thank USC, who did a wonderful job hosting a series that looked at some of these very significant issues, and this is really the culminating moment of that series. I realize as I scan the room that the expertise is not limited to the people sitting up here. We have some individuals here in the room with us who are tremendously knowledgeable, expert, and engaged in these issues. So I really view all of us up here as sort of the conversation starters, and all of you as equal partners and participants in that conversation. And that's very much how we hope that the next few hours will unfold, that you'll hear some of the perspectives of these individuals up here, but that you all will join us in together thinking through these issues and starting to see how we chart this exciting, in my mind, new territory ahead. I think we can all agree that we are at a time that poses tremendous challenges in the wake of realignment. We are clearly at a time of limited resources where everyone is being asked to do more with less. But in my mind, this is also a time that very much exemplifies that saying of we can't let a good crisis go to waste. I think that we find ourselves at a time of tremendous potential where scarce resources and new approaches are going to force us and encourage us to think about innovation and think about smart approaches to justice, not simply perhaps some of the knee-jerk approaches of the past. Clearly, the criminal justice system is an area of heaviest investment of our government entities. But we also know that we have strong community support, and we'll hear some of those voices and have them in the room with us as well. Strong community support for prevention, for early intervention, for diversion, and for rethinking how we handle these issues, while also, first and foremost, keeping our communities safe. We know that there is new thinking afoot. We know that we have new allies in the mix, that we see law enforcement, prosecutors, community groups, and those on both sides of any aisle, political spectrum, or issue coming together to try to forge solutions. And we also know that here in Los Angeles, we find ourselves at a tremendous moment of potential through new transitions and new leadership. We have a new district attorney, a new city attorney, a wonderful assistant sheriff over custody, and a probation chief who are all relatively new on those jobs. We have voices and engagement from our community that's being lifted up in a way it hasn't before. And we're seeing that cooperative thinking and engagement is vital and productive. So today our conversation will be about how we move forward, what new ideas can guide our thinking, and how we do that thinking together in a smart way. I can think of few better people in LA County to launch that conversation than Supervisor Ridley-Thomas. The supervisor really needs no introduction, and I won't cut into his time by doing much in that regard. As I'm sure you all know, he's the chairman of our Board of Supervisors. He so ably and passionately represents the 2nd District. But I think most importantly, he's modeled throughout his career courageous leadership and critical engagement with his community. He has stayed throughout, tethered to those voices that care about how we lead looking forward rather than looking backward. He is truly the definition of an innovator. And with that, Supervisor Ridley-Thomas, we look forward to your thoughts about how we engage in the conversation ahead.
It's the nicest thing Bruin has said about a Trojan in public in a long time, and so we take the opportunity to get this panel off to a good start. I'm pleased to be here and thank the panelists for their time, the co-sponsors, the University of Southern California, the Reaver Group, Californians for Safety and Justice. All of them are deserving of our acknowledgement and our praise for being here to convene this conversation. My remarks are not particularly long. They may be more provocative than anything else, and if I serve that purpose, my job will have been done in a satisfactory manner. There are 3 areas that I want to point to as quickly as I possibly can. One is AB 109, editorial remarks such as it is. And then I want to talk about jail reform, editorial remarks such as it is. And then I want to sit down, editorial remark, so you all will be happy. All right, the coffee's over there. You all need to wake up and get with the program. I've provoked you 3 times already, and you were not appropriate in your response. Therefore, we have a problem. That's a little better. That's a little better. How about AB 109? From my perspective, it is challenged. From my perspective, it was driven by the impulses of state government, particularly a governor who knew that he had a problem in balancing a budget in part, but also the real issues of a mandate to clean up state prison. But what was not appreciated was the gravity of the problem connected to those individuals who were characterized as being nonviolent offenders. The severity of the challenges that they have personally, I think, as it relates to what local government had been told, was underestimated. Now, do I choose to impugn anyone's motives? I do not. But the realities are that these are individuals who have substantial challenges, not the least of which are severe, pressing, very important, very unnerving mental health challenges. Just straight talk, ladies and gentlemen. And the notion of nonviolent offenders often gives the impression that we're dealing with a benign phenomenon, and that is not the case. Feedback of the 15,000, near 15,000 individuals who've been released on post-release community supervision, if you had to rate them between high, medium, and low, a disproportionate number of them are high risk, if we were to believe the chief probation officer, which has far-reaching implications for how law enforcement organizes itself to respond to that particular impact. If they were largely low risk, then a different set of resources could come forward. And so the model that we would wish to hope to emphasize, namely that of reentry, reintegration, focused on the principle of redemption and rehabilitation, gets to be a bit removed because the pressing need to deal with the matter from the perspective of public safety, and often tied to the issue of suppression, not even intervention. And the mindset that has enveloped the probation department, as I view it, is precisely that. So I keep pushing the discussion where in this conversation is space for the issue of reentry. I want to see those who have been released become constructive contributors to their community. And I would wish to cause us to appreciate that there is, in my view, too little attention focused on that aspect of it. And so community entities who wish to help individuals get back on their feet and gain their sense of worth and dignity in the context of our communities are saying that isn't happening. Why isn't it happening? Why aren't the resources being allocated to cause that to happen? And I think in fairness, it's in part attributable to being overwhelmed with the challenges that I just described, the demographics of those who have been released in terms of the specifics of their challenges and the notion of recidivism and reoffending. There's a challenge even in the context of not a fully embraced common operating understanding of recidivism itself. What does it mean? And how are we going to measure success? And so mine is in large measure a critique of AB 109 in this instance that suggests that there's a lot of work to be done. I'm least interested in counting these numbers as much as it would be my desire to see that we creatively, imaginatively engage in how we confront a range of problems with which we have to contend and boldly figure out how we work on issues of redemption, how we work on issues of rehabilitation, how we work on issues of reentry. Otherwise, we are essentially engaged in the business of recycling unimaginatively. My initial comments about AB 109 is that it leaves a lot to be desired at this point. I wish to see a more robust focus on mental health and treatment. I wish to see more emphasis on job training, education, and workforce-related activity. I wish to see much more emphasis on how we help people put their lives back together. I see at this point too few examples of that. The expectation that I would have had, perhaps naively, is that we would have had by this time more examples to present of how that was to be the bright light of moving nonviolent offenders into a new place with respect to probation rather than parole. My initial remarks caused you to appreciate the extent to which that which I hope would happen or had hoped would happen is daunting in light of the preponderance of individuals who are quote-unquote high risk. Sobering thought. So in the local space, there's a lot of pain and suffering related to whether or not the governor pulled one on us and just dumped these problems on local government. And it becomes most problematic in the context of a county, anomalous though it may be, as LA County. We have to look across the state and see who's faring more effectively and raising up models that call on the resources of community-based organizations, faith-based organizations, et cetera, in a way that I would have hoped and still hope can be the case for Los Angeles County. Because from my point of view, that's when we will have made most sense of what AB 109 should at its best be. I have no concerns about being contradicted with respect to my sentiments on this matter. It is essentially a considered point of view that I am prepared to assert, articulate. Ladies and gentlemen, that's my story, and I'm sticking to it. Now, before I take my seat, I want to say a little bit about the Sheriff's Department. And you remember there was a big fight between probation and the Sheriff's Department initially as to who was going to really run the AB 109 program. And the Probation Department ultimately prevailed. And that's before the current leadership in the Probation Department. But there was a significant point of tension. Sheriff Baca and Don Blevins, former chief probation officer, had a little bit of a tete-a-tete on the issue of who's going to be the big dog on AB 109. And the Board of Supervisors was ultimately convinced to cause it to be the Probation Department. Well, my grandmother told me a long time ago, Mark, be careful what you pray for. On the question of jail reform, significant work has been done in that regard. The Citizens Commission on Jail Violence, Miriam played a huge role in that regard. As has already been indicated, the objective here is to look at structural reform as best as possible, looking at 63 recommendations, trying to get toward implementation, currently in search of an inspector general to inculcate a sense of transparency and accountability in the department. Not easy. Cultural transformation is never easy. A lot of tension attached to that. The role of the Sheriff's Department, how prominent, dominant would it be in interfacing with the Office of the Inspector General? My view is it shouldn't be much at all. Others say, well, you know, there has to be collaboration in order for it to work. No, there has to be accountability in order for this to work. And the Sheriff's Department just needs to understand and appreciate that. The problems that we experience up to this point, in my view, are directly attributable to the fact that there's a lack of an appropriate level of external oversight of the Sheriff's Department, and therefore I maintain my position. Not only do we need an Inspector General, we need a Citizens Commission that is essentially an oversight entity. And if anybody's under the mistaken impression that the Board of Supervisors can do it, think twice. We cannot sustain the level of attention that is warranted by virtue of the demands on our time otherwise. You would think that there is no issue of jail reform of consequence in the County of Los Angeles today by virtue of the fact that the Department of Children and Family Services has taken front row in terms of headlines and the profundity of challenges in that department. So our energies are significantly focused there. And in the meantime, the Sheriff's Department business goes on and on and on without the benefit of the level of civilian and or independent oversight that is required. And so I'm not speaking ideologically here, I'm speaking practically. If you want reform, you have to have sustained and systemic oversight. And I think the sheriff himself has put in place additional personnel that come with credentials that are noteworthy, and you'll hear from such persons this morning. But the bottom line for me is that it is not about the individuals. It's not about Baca. It is not about McDonald. It is not about Ridley-Thomas. It's about how you design a system of accountability, irrespective of personalities. And that's what's significantly and conspicuously absent. There's more deference to individuals than there is attention to the intractable nature of the problem, unless there is the significant kind of intervention that's required to confront many of the problems that the Jail Commission itself uncovered by virtue of its rather extraordinary work. So if I were to leave you with any particular point, it would be that. Citizens' oversight. The unique nature of the problem in the city of Los Angeles or the county of Los Angeles relates to the fact that, of course, the sheriff is independently elected. Our charter doesn't permit the Board of Supervisors to run the sheriff's department. State legislation would have to be engaged in order to redefine that whole range of things. It's not analogous to the city of Los Angeles in the sense of having a board of commissioners appointed by the mayor, confirmed by the council, a different set of issues here. But there's always a way to figure out how not to do what's necessary to do. In my point of view, we need to will our way into WILL into doing what's necessary. Otherwise, we will find ourselves in the same position over and over again. The moment is now for systemic change, and that has far-reaching implications for oversight that frankly can be appointed by the Board of Supervisors. We appointed a jail commission, didn't we? Did a good job. Why then can't we appoint a citizens commission of individuals who will do what need to be done? Those are my thoughts on the subject at hand. Marion is rattling her papers, which seems to me, as an able moderator, Mr. Supervisor, sit your Trojan derriere down. Thank you very much.
Well, Mr. Supervisor, I'm not sure I would have quite said it that way. But thank you for those remarks. I think certainly that is food for thought. And, I think just to build off of the final sentiment, I think we can all agree that we are sort of at that moment of, are we going to adopt the so-called Albert Einstein approach, the definition of insanity, doing the same thing over and over again and expecting a different result? Or are we going to find a new way and a new path? And certainly with leaders such as Supervisor Ridley-Thomas, I think, and our new leadership in the county, some of whom are up here, I think we really have that moment to try to find that different path. So let me then introduce our wonderful panelists and let us get underway. And I will say that my solution when the room is too quiet, because I do spend a lot of time in the classroom, is to simply call on you. And I know so many of you out there, so I know I could call on you. So hopefully we will find the engagement with all of you. And I do tell my students that sitting at the back of the room is no way to avoid that. If I can see you, I can call on you. So just be forewarned. So we have a wonderfully accomplished panel. I believe that many of you know them, and I want to do very brief introductions so we can really get into the substance pretty quickly. Immediately to my left here is Lenore Anderson, who is the Director for Californians for Safety and Justice. And those of you who aren't familiar with the great work of Californians for Safety and Justice, I would encourage you to go to their website and learn more about the work that they're doing. She came to that initiative with a wealth of justice system experience, having spent time in the San Francisco District Attorney's Office, where she spearheaded a number of initiatives aimed at reducing recidivism and improving public safety, having been the Director of Public Safety for the Oakland Mayor, having served as the Director of the San Francisco Mayor's Office of Criminal Justice, among others. And more than really any other voice in the state, if you think of smart justice and smart innovation, think of Lenore, because she is exemplifying that. Immediately next to Lenore is our recently appointed Assistant Sheriff, Terri McDonald, who is overseeing the custody division. I think probably the thing I will look back and take greatest pride in by virtue of the work of the Jail Commission is the fact that we created the position that enabled Terri McDonald to come to our county, because I really think that she's bringing with her a breath of fresh air, and we're so grateful that we were able to steal her from CDCR. She was a 24-year veteran of CDCR, worked her way through the ranks of that department, and oversaw some of the most challenging and most critical issues at the time that she left, over time, including juvenile justice, gang issues, fugitive issues, rehabilitative programming, and how to rethink post-realignment strategies. Seated next to Terri is Alex Johnson, who has a pretty good boss. He serves as the Assistant Senior Deputy for Education and Public Safety in Supervisor Ridley-Thomas's office. He is probably the one who, whenever there's a great idea, is told, Alex, go do this. And luckily, Alex is there to see that good ideas turn into reality. He handles deployment, oversight, implementation, and integration of the many efforts within the supervisor's office focused on education and public policy, public safety policy priorities and initiatives. And he came to that job as well with a wealth of experience, having been an attorney in the General Counsel's office in New York, having taught, and having served as an assistant district attorney in the Bronx County District Attorney's office. Seated next to Alex is Susan Burton, who I came to know through the Jail Commission work. She is a wonderful voice that has brought the perspective of the community continually and passionately to these conversations. She's the founder of a New Way of Life Reentry Project, which provides housing and support services to formerly incarcerated women in South Central Los Angeles, and she has truly dedicated her life to helping women break these cycles of incarceration, homelessness, addiction, and despair. She's a recognized leader in criminal justice reform and reentry rights movements, and truly has been that passionate voice to keep the drumbeat strong. And finally, seated at the far end, is Reaver Bingham, who is a 30-year veteran of our county's probation department, where he's held a host of positions through the years, including currently serving as Deputy Chief of Field Services Division with primary responsibility for the implementation of AB 109. So he is sort of the person with the target on his back, or the one kind of at the focal point of the brewing fire in trying to get this right. We promise not to take aim at you, Reaver. So with that, I would like to have us start our conversation by just making sure that we have a common understanding through some information that Alex is going to provide to us of what does the data look like? How do we know what the starting point is to start to think through these issues? And what has been the work of Supervisor Ridley-Thomas's office in implementing these reform strategies and new approaches in the county? So starting up with you, Alex.
Thank you, Miriam, and thank you to Californians for Safety and Justice, the Reaver Group, and USC for hosting this important conversation about rethinking and re-envisioning our public safety policies in LA County and statewide. Let me just acknowledge my panelists again. I'm honored to be included among this distinguished group of individuals. And I've been asked to do just a few things. As Miriam said, I've been asked to provide some context to our discussion today, to provide some key data and numbers regarding public safety, criminal justice policies in the state. Also asked to discuss some of the current efforts and opportunities that we should be focused on, and to also briefly discuss the role of the Supervisor's Office in implementing some of the reform strategies in LA County. I'm going to spend the bulk of my time in my opening remarks just giving some context and background data for this conversation, and to show what we're up against, number one, and also to understand the framework that we currently operate in. And so let's look at it by the numbers. California has the second largest prison population in the country. We're bookended by Texas, which is number one, and by Florida, which is number three. According to CDCR, the current population in California is about 133,000 individuals who are in state-run facilities. And that's gone down since 2012, when the number was at 135, 136,000. And in 2010, that number was even higher, around 150,000 individuals. And overall, we have nearly 195,000 individuals who are under the jurisdiction of the California Department of Corrections and Rehabilitation. Our state prison population is overwhelmingly male. We have about 94% men in our state prison population, about 6% are women. And that issue of women in prison, women who are incarcerated, is an issue that largely goes unaddressed. And the rate of female incarceration in California has outpaced that of males over the last few decades. There was a recent study that found that over a 28-year period, the total number of incarcerated women in California grew exponentially, about 892% for women, about 866% for men. California overall has the second largest population of women who are incarcerated. And this is something that's important, something that we need to understand. And again, Texas outranks us in the total number of women who are incarcerated. Now, overall, when we're talking about our state prison population, when we're talking about the makeup of our statewide institution, we're talking about a system that is disproportionately minority. Regardless of gender, about 3/4 of our prison population is non-white. And there's something inherently wrong with that picture. The intersection of race in our public safety policies and our criminal justice policies has a significant impact on how we view them and how we address them, from both a local perspective, from a state perspective, and from a federal perspective. Incarceration destroys the fabric of our family, the disproportionate number of males in prison, and smart public policy must look at the issue of criminal justice holistically. What can we do to strengthen families? What are the predicate factors that lead to incarceration? How do we promote diversionary tactics? How do we increase our focus on mental health and the environmental factors that the supervisor spoke to a few moments ago? And so these are some of the questions that we must ask ourselves. Now, LA County is central to this debate. The uniqueness with LA County as it relates to law enforcement and incarceration is clear. We're the largest county in the nation with about 10 million individuals, the largest of the 58 counties in California. We have the largest sheriff's department. We have the third and fourth largest policing agencies in the country, the LAPD and the Los Angeles County Sheriff's Department. And importantly, we have the largest probation department in the nation. About 81,000 individuals are under the jurisdiction of the LA County Department of Probation. One of the things that gets lost in that conversation is the issue of juvenile probation. LA County has the largest juvenile probation department in the country. And currently about 16,000 individuals are under the jurisdiction of the LA County Probation Department. And that number has gone down from a few years ago at a high of around 21 to 22,000 individuals. And when we talk about our county jail system, we're talking about 8 facilities that make up the county jail system, approximately 19,000 individuals. And that number has increased since the advent of AB 109, where the population hovered around 15,400 individuals on average. And if we look at our inmate profile, we're looking at a few things. Overwhelmingly male, about 16,300 men, 2,400 women. The majority of these individuals are classified as medium security. The average age has been around their mid-30s for both men and women. Interestingly enough, over half of these individuals, about 10,000, are considered pretrial inmates, so they're awaiting trial, haven't been adjudicated. Mental health needs are prevalent in our jails. Gangs are prevalent in our jails. Twin Towers is the largest mental health institution in the country in a facility. And the demographics of the LA County jail system are similar in many respects to the state, disproportionately Latino and African American. And this is disproportionate because African Americans make up about 9.3% of the county population. Latinos make about 48.1% of the population. But yet we're still facing disproportionality. So let me close my opening remarks providing these key numbers for you to inform this conversation by stating the following. The issue of mass incarceration in Los Angeles County and California is prevalent. There is a revolving door between our juvenile facilities, our state facilities, and our jails. Many of these young men and women spend their lives incarcerated, the balance of their lives incarcerated, or end up dead at an early age. It does not benefit our communities. It does not benefit law enforcement. It's not smart justice. So I'm a former prosecutor. There are folks who need to be in jail. I prosecuted domestic violence crimes for a number of years. Folks need to be in jail. But there are many who don't. And so we cannot incarcerate our way out of this issue. We cannot incarcerate our way out of the systemic issues that we face. Our policies cannot just focus on suppression. We need to insert some other words into our policy formulation, words like diversion, words like treatment, words like rehabilitation, words like reintegration, words like reentry and intervention. Those words need to be included in our public policy formulation. And so I'm going to lend the balance of my time and thank you, Miriam, for giving me this opportunity to present.
Thank you, Alex. And I should know that after these initial remarks, I will try to ante up some follow-up questions, and then we will have the opportunity, we'll be passing around note cards for all of you to identify questions of interest for us to be offering up to the panelists as well. I think Alex very well kind of laid the backdrop. He may have also depressed us in the process, but that's okay because we're going to move beyond that and really start to think together about what do we do in light of that backdrop. And I think he's teed up quite well for our next speaker, Assistant Sheriff McDonald, to help us both further understand what do we mean by realignment. I think it's at times perhaps even an overused term, but what exactly is realignment? And second of all, how has realignment been impacting the jail and probation services? And what have you seen in terms of new approaches, alternatives to incarceration, and innovation that's been happening to try to address, in particular, some of our lower risk population?
You know, a bureaucrat loves a PowerPoint. Well, first of all, let me, while he sets this up for me, thank you for the invitation to join this important conversation. I think as I speak today, I wouldn't disagree with anything Supervisor Ridley-Thomas said or Alex has said. There's a complex, this is complex social issues, and I think it's worthy of discussion. I think it's worthy of the challenge we're up against. In my role with corrections, I left as the undersecretary, so I oversaw prisons, parole, juvenile justice. But one of my side jobs was to implement AB 109. And so not only did I have to deal with the downsizing of the state prison system, I also served as the conduit between the counties and the state. Reaver Bingham and I had many late-night conversations, early conversations, struggles. Reaver would holler about what the state wasn't providing. Mental health, the supervisor's office brought us up and said, you know, what are you doing? Margarita Perez, the lovely lady in the red dress in the third row over there, was the deputy director of state parole at the time, and we all struggled to make it work. I will tell you, though, that LA County, despite all the challenges of the quick implementation, did what they could to ensure public safety as we went. I wanted to start a little bit to talk about the law itself, because I think some people understand it, some people don't. There's some misconceptions about it, and so I thought that would be a good place to start. So public safety realignment really has a variety of things that it talks about. It talks about local custody, who comes to jail and who goes to prison. It talks about who goes to state parole and who goes to state supervision under PRCS, or here it's called post-release supervision, or PSP. It requires a local planning committee, and it talks about the role of the court in adjudicating violations of state parole. It began in October 1st of 2011. Those folks that can remember back, it was initially supposed to start July 1st of 2011. And the counties were legitimately saying, this is craziness. We cannot take this number of offenders, LA County particularly. A third to a quarter of all state prisoners come from LA County, and a third to a quarter, depending on what year you look at it, load out to LA County. And that's a huge shift of population. I think Reaver can talk about, he was getting packages by the hundreds of inmates he was going to supervise. So originally it was supposed to go into effect October 1st. The court's addition, or July 1st, it got moved to October 1st of 2011 to allow more preparatory time. The courts were also supposed to take on parole violation hearings July 1st of 2011. It then slipped to October 1st of 2011. It slipped again to July 1st of this year, and I'll talk about that. So we need to kind of understand who serves their time in jail. Prior to public safety realignment, felons who had less than a year time left to serve generally served that time in the county jails. Those felons who had more than a year went to state prison. Public safety realignment eliminated that time frame and essentially said that if you are sentenced to a felony, and that felony is not a serious, violent, or sex offense as defined by the penal code, or you don't have a prior serious, violent, or sex offense, you stay in county jail, right? It doesn't matter how much time you have left to serve, and I think there's some confusion there. Under Schwarzenegger had proposed that anybody serving 3 years or more would go to state prison, so there was a lot of confusion early on under the Brown administration proposal. There's no limitation to the amount of time that people can serve locally. And you'll see in a slide later what kind of time people are serving in county jail. I don't want to trump that slide. Good. And then who goes to state prison? Well, the people that go to state prison have a current or prior serious, violent, or sex as defined by the penal code sections written above. And so there's criticism that some offenders who committed what most people would consider a violent offense are still serving their time in county jail. There's some domestic violence issues, for example, that serve their time in county jail. Well, it's not because maybe I don't consider that a violent offense, it's because the penal code doesn't. And so there would have to be changes to the penal code. A prior offense goes to state prison. If they're a sex offender, they go to state prison. There are some small crimes, though, that cannot go to state prison, or that go to state prison that are odd. And a good example is selling horse meat. And you're probably wondering why, or bribing a legislator. Those are really not considered serious or violent by those penal code sections, but they were enacted by 2/3 law. And so as a result, public safety realignment couldn't trump those sections of the penal code because public safety realignment was put into law by majority vote. So you have to remember, when realignment went into effect, there was this convergence of issues. You had the United States Supreme Court saying that California prisons were grossly overcrowded and they were going to order an early release. You had a budget crisis where the governor decided not to buy beds or build his way out of the crisis. And then you had a democratically controlled legislature where you could get majority vote. And so it was this convergence that really allowed this to happen. I think without those three items, I'm not sure what would have come of it. So that's who goes to state prison, that's who goes to county jail. It also allows for, because there was no doubt that many counties didn't have capacity to deal with the offenders that were going to be placed there. Riverside County, for example, LA County, Fresno County have been doing early releases prior to realignment because there wasn't enough capacity. So it allowed the courts to do what's called a split sentence. And what the split sentence means, and I'll just make up a story, and Reaver could probably do a more artful job of it. But if my crime could be subject to 6 years in county jail, automatically I serve 1/2 of that. Automatically I only serve 3 years. The law allows the court to say, okay, Terry, you'll spend 2 years in jail and 1 year, 1 year on probation supervision, right? So that's called a tail. If you hear the term a tail, state prisoners, when they leave, the vast majority of them are automatically on parole supervision. But that's not true under realignment. The court has to order the split sentence. Statewide, about 20% of offenders are getting a split sentence, AB 109 offenders, but that is skewed because LA County is one of the biggest counties sentencing people, and only about 5% of the population, and representatives from the district attorney can correct me if I've got that wrong, but about 5% are getting split sentences in LA County, which pushes the number down. If you pulled LA County out, it's probably about 40%. And we can talk later, and maybe River can talk about split sentences, and we could talk about what happens when you don't have a tail and how that's not necessarily the best interest of public safety. Counties are allowed to contract back with the state. The state didn't accept any contract backs. The only thing, and because they're crowded, the only thing the state is working on is contracting back fire camp capacity. Many of the offenders who got realigned to the county, if they were in state prison, they'd be working fire camps, right? And so as a result of realignment, the inmate firefighter fire camp population went down. And when you watch wildland fire suppression out there, those are inmates fighting the fight. Not all of them, but a percentage are inmates. And so we are currently seeking the ability to contract with LA County, or LA County with California, with CDCR for fire camp suppression. We can contract with community correctional facilities if the Board of Supervisors so chose and the county so chose. And it gives the sheriffs expanded potential to do alternative custody programs. And I think we'll talk about that at length today. We should, because you've heard it said that you can't build your way out of this problem, right? And a jail bed's not the solution for everybody. There are people who need to be in jails and prisons, no doubt, but there are better outcomes from alternative custody that we can talk about as we go today. It allows for home detention. It allows for credit, so they get day for day, as I mentioned to you earlier. Now, here are two things that are widely misunderstood. Every state prisoner finishes their sentence in prison jurisdiction. The Secretary of Corrections doesn't have the legal authority to do an alternative or to an early release. They cannot. They have no legal authority whatsoever to do that. Now, there are probably 100 women sentenced to state prison serving an alternative custody program in some program in the community. But there's a lot of confusion about this person that committed this crime, they were an early release from state prison. That's not accurate. No state prisoners were transferred to jails. So if they were in prison when realignment went into effect, they stayed in prison. It was all after that date, people were sorted. Are you a jail inmate or a prison inmate? Now, corrections will always say, we haven't done an early release. AB 109 is not an early release program. Well, that's not exactly true. While the state's not doing early release, counties are, because they have federal court caps, crowding levels, that they're required to release inmates prior to the finish of their sentence to be able to comply with federal court caps. Okay. And I'm going to steal Reaver's thunder and just take this one, and he can answer follow-up questions to it. So the first part of AB 109 was who comes into prisons, who comes into jails. The other part of it is who goes out and who supervises them. Prior to public safety realignment, inmates leaving state prison went to parole supervision. Post-public safety realignment, they are screened by prison staff, and either they go to state parole supervision or they go to county supervision. Okay? There is a fundamental difference about who goes in and who comes out, and I'll tell a story about that. It is, if you see there, it's current. It's current nonviolent, current non-serious, and non-high-risk sex offenders. So I'll make up a story. If I'm an inmate and I was a rapist 20 years ago, I was convicted of rape, and I'm resentenced for car theft, I would go to state prison because I had a prior serious sex offense. When I come out of prison on my car theft, right, I go to county supervision because it's a current non-serious, non-violent, but I have a prior sex offense, unless I'm a high-risk sex offender, very technical part of the law. So when the supervisor talks about the confusion about the county's only supervising low-risk offenders, that's not accurate, right? And I don't, and I'll take accountability. I don't think we're artful in really explaining that, right? And frankly, high-risk offenders, there's not a lot of low-risk offenders that go to prison in the first place, right? If you pull a rap sheet on somebody sitting in prison, they're not the first-time drug possession person. They've got rap sheets pages long. And so who goes into prison? It takes a lot of work to get into prison, right? A lot of people do time and probation and stuff before. Who doesn't go to probation is a third striker, individuals with a serious, a violent, or they're a high-risk sex offender. What happened is, of course, the counties need to know who they're getting. And so a law was passed that required that the state gives the counties information on who's coming out 30 days prior. Mr. Bingham can talk about this, but probation will get information about who's coming out. Probation will look at their conditions and then issue their conditions of release before they come, so they know where they're going, and Mr. Bingham can talk about that. So post-release supervision allows for revocations up to 180 days. Prior to public safety realignment, a parolee who violated their conditions of parole could be revoked by the Board of Parole hearing for up to 1 year with no credit earning. They served that time in state prison. Okay? So this doesn't look like a big difference, but it's a huge difference. Again, prior to public safety realignment, a parolee could be revoked for 1 year, served in state prison without credit earning, so they serve the whole year. Post realignment, they can be subject to 180 days revocation, served at halftime in the county jail. So they went from a potential 100 days to 90 days. Okay. So it does that. It allows graduated sanctions, including flash incarceration. Mr. Bingham can talk about the value of flash incarceration and swift and certain sanctions. Individuals who are compliant with their conditions of release can be discharged from probation or parole supervision. And then the courts will take on parole violations of state parolees effective July 1. That's a huge impact to the courts, right? They currently do probation. The court does probation, but parolees are done by the State Board of Parole hearings. And so that's being discontinued July 1, and the courts will take that workload on. It'll be interesting from my perspective to see what happens from that. And I think parole is going to have to come up with some more innovative ways to manage violations of parole, because I don't think courts are going to do revocations the same way the Board of Parole hearings would have. And Ms. Perez could speak if she thinks I bumped my head. Anybody on post-release supervision, CDCR has no jurisdiction over them whatsoever. There is a law that's working its way through the budget process now, and it was driven by LA County, and it's a smart law that says if you were previously a mentally disordered offender and parole supervises this very small, nuanced group, if a court decertifies you as a mentally disordered offender, you stay on state parole supervision. What's happened in LA County is, I think, 3 to 5 offenders who are mentally disordered offenders, mentally ill, can be pretty violent, have been decertified by a court, and then probation ended up having to pick them up. So that law is making its way through. There's another law making its way through that says if the state made a mistake and put you on state parole or county supervision, and by law you shouldn't have been under jurisdiction by that entity. If you've been under jurisdiction by them for 60 days, you remain under their jurisdiction. And then the only people that can be returned to state prison for a violation of parole are lifers. And if anybody wants to guess how frequent that is, it's not often. So that's not a lot of them. Post-release supervision. So the Sheriff's Department, the supervisor talked about kind of the challenges between LA County Sheriff's Department, LA County Probation, pre-realignment. The Board of Supervisors made the decision to give supervision to probation. By the way, post-release community supervision are supervised by probation in all 58 counties. But it did ask the Sheriff's Department, the board did ask the Sheriff's Department to take on some role. So they help with address verification with probation. They help with people that aren't showing up for probation. They help hunt down absconders that take off. They're helping with database information and monitoring. And they help do compliance checks. Alex and I may have different numbers. That's not unusual. Numbers are always fluid because they're all point in time. But this will give you an idea of what the state prison looked like pre and post realignment and parole. So pre-realignment, there was 160,000 inmates under CDCR jurisdiction. When this was run probably a few weeks ago, it was 133,000. Now, the three-judge panel is not about all inmates in prison. The three-judge panel is about the inmates in the 33 brick-and-mortar prisons. And so the second number is the prison population. There were 148,000 inmates in the 33 brick-and-mortar prison. The three-judge panel required to get those 33 brick-and-mortar prisons down to 110,000. So there was a gap, you can see, of 38,000 prisoners needed to reduce. A realignment was successful in reducing it to 123,500, but it's pretty much static now. So there is a gap of about 13,000 that is still being fought and debated all the way back to the United States Supreme Court. Parole population had 105 at the height of parole population. I think they had 130. Prior to realignment, they had 105. They're down to about 53,000. And then you can see what happened in LA County. There were about 33,000 inmates on parole in LA County. Now it's been cut in half, and you see who's picked up that workload is probation. And these numbers could be wrong, Reaver and Margarita, so I apologize if they're off, but they're probably close enough for discussion purposes. So what's happened in the jails? So in the jails, here's what we've got. We've got 18,700. I think we're more like 19,000 this morning. Station workers or inmates that work in the local jails. There's dozens of jails in the community. So there's some inmates working in there. And then we have 5,700 inmates who are sentenced N3 population in the jail. So these are longer term offenders that we really have to come up with a more nuanced approach towards managing them because they're there longer. Essentially, we're running out of bed capacity because we've run what's called bed vacancies or swing space. I'm reducing that because it's too much and it's expensive. But anyway, it's just a capacity thing. So one of the things that we really need to talk about and consider is what do we do for jail population options? Well, fire camps I talked about. Community-based alternatives, there's electronic monitoring, work release, inmate station workers, and there's CCFs. But none of those really are proven to reduce recidivism. The things that reduce recidivism are substance abuse housing, homeless shelters, things that really target people's criminogenic needs, right, where we're investing on the front end to keep them from coming back in jail. And so I'm hopeful that folks are willing to engage in the discussion about how we do that and help find resources to do that. And I know that's why we're all kind of here today. I'm certainly willing to lead the discussion from my end. And this is who we have under AB 109. So you can see that since we've started, we've got about 12,300 of them. But the interesting part is this number 382, inmates with 24 months plus left to serve. So they're serving over 2 years in the jails. Jails aren't built with a lot of program space. And so it's been a real challenge. And I will tell you, if you were to ask me the reason that I came to LA County, it's because I wanted to be part of a more grassroots issue. With the state, it was so big. You know, I'm just in hearings, I'm leading policy, I'm doing all of that. Here, we have the opportunity synergetically to make massive change. And I knew we could do it because the sheriff has a program called evidence-based incarceration, where he's gone in and taken areas of the jail and converted it for program space. You don't find that in every county, right? I want to take it in a few more steps. You know, mental health, substance abuse, gender-responsive strategies for women. There's a lot more left to be done. But I didn't walk into an environment that needed a knock on the head to say we've got to do it differently. The sheriff already led that through education-based incarceration. We just need to expand it. And we need to make sure the programs that we're providing are evidence-based, and we need to have aftercare, right? And let me go back to the split sentence issue. The lack of a split sentence on these N3 population means that when they get out, we have no jurisdiction over them, right? And we have no ability to pay for their programming. And so we've really, and we had a great conversation with the district attorney's office this morning before this started. You know, we've got to talk about how we program them while in custody, and then how we have a program for release. Is that you telling me to get off the mark? Somebody give me the hook. Because look at here, we have 31 guys serving 10 years. Our longest sentence is 42 years, right? But it is ripe for the discussion. One of the questions, I think that's pretty much it for the PowerPoint. I'll step aside. But one of the discussions that I was asked to talk about is what are some of the things that work? Well, what works and what doesn't work? What doesn't work is warehousing people. I know it well. I did it in the state, right? You bring them in the system. You don't give them a program. They just do their time. You make them a kitchen cook. You have them clean the yards. All of that. It does not work. The state's recidivism rate on the last report was 63%. 63%. If you start to talk about mental health treatment, it can run as high as 78%, right? What does work, though? The state reports that if you put an offender with a drug problem, not a drug dealer, right? Not a drug dealer in a substance abuse program, but you find an offender with a drug problem, and you put them in an in-custody substance abuse program, and you put them in an aftercare program, and they complete that program, recidivism rate's 31%. Right? Those are the kind of things we need to talk about. You know, release begins at intake. Reentry begins at intake. They come in, you do a risk assessment on them. You place them in a program that's evidence-based based on their criminogenic needs. We partner with probation, parole, whomever, to plan for their reentry aftercare, and you find appropriate housing for them when they go, and you monitor them. I know from AB 109, it is hard. When there is no potential stick on some offenders, you can't get them to change. It's no different than us, right? You're most likely, after you have a heart attack, you're most likely to exercise and eat well, right? You are. You've had a heart attack. I'm going to change my life. Thank you, Lord. I'm going to live, and I'm going to exercise. I'm going to work out. But after time, those cheeseburgers and pizzas start looking pretty good. When they hit the jails, they're in crises. That is the time to hit them. And then don't just release them to the street with no plan, because otherwise they're going to come back. And that's the recipe for success. And I thank you for indulging me for the long dissertation on realignment, and I'll be available for questions.
Well, thank you. And I know that we'll have the opportunity to continue some of that conversation about how do we further, in essence, feed that recipe for success and some of those ideas. Our next speaker, Susan Burton, really is the best expert we could have up here to help us think through what do community partnerships mean and how do we help promote them. We know that they're vitally important, and Susan's going to give us her thoughts on how they're working and how they could work even that much better. So thank you, Susan.
So I really want to thank everyone who's been responsible for putting together the series of Rethinking Criminal Justice. It's a really lively conversation headed in hopefully a good direction, and I want to be really thankful that I've been invited to participate in a couple of these talks. So A New Way of Life was created in 1998 following my 15-year experience in the criminal justice system. I used drugs and alcohol. I was incarcerated for the drug part and was sentenced to prison 6 times. There was no, not ever did a district attorney or a public defender say, you have a substance abuse problem, let's get you some help. I can remember going to probation, talking with the probation, and really opening up and laying my life out to them and telling them that my 5-year-old son was accidentally killed by a policeman and I fell into an addiction. And I was just blown away when the report came back and said, state prison. This is what we say she needs. So again, I went to state prison. After then, I was just shut down and in a cycle. So 1998, I got help. I got help in Santa Monica and left Santa Monica, coming back to South LA, saying that this really worked, and I never should have been incarcerated, and there was a dawning. Knowing all the women I had met while being back and forth into prisons, that they needed something like this too. So I started a New Way of Life. I worked, I got a little house, and began to invite women into the house, and that birthed a New Way of Life Reentry Project. So since then, over 700 women have been in those homes. There's now multiple homes, and over 150 women have been reunited with their parent. Women have been reunited with their children. When realignment happened, we really, advocates across the state really celebrated. We cheered because the California Department of Corrections could no longer house people in the fashion in which they were housing them. It had been declared unfit for its capacity, its overcapacity to operate in that fashion. And we really rallied and cheered, and here we are in the second year, and it's looking, like a really dismal failure. And it's looking like LA County is about to do the same thing, or in the process of doing the same thing that the state of California did at the prison level. So, when I started in the Way of Life, there was such freedom in what I was able to do and how I was able to operate, what I could offer and who I was working with. And over time, we grew from just me to staff and a lot of different requirements. But last year, we partnered with the AB 109 Probation through Health Right 360, and as a former prisoner, as a director of a nonprofit, as an advocate for the rights of formerly incarcerated people, our homes, our family unit, we operate as a family, one woman supporting the next woman and me supporting everybody. And it's just starting to look a bit different. The subtle ways in which people are the residents are having to be accountable, and the organization having to comply with different regulations per the contract. It just is looking a little bit different from the happy, lively home that it once was. So why do I wake up in the morning and I have to sign in and I'm at home? Why do I have to be guarded all day and all night? So I can't have this level of, we operated at a level of family, unity, and accountability. And that's all gone now. but the homes are still there. The women are thriving, but I don't know how long that's going to have that type of heartbeat within our homes because of all of the different compliances. I'm grateful to be on the other side of incarceration and in the community and working for a better community. But when I look at what's happening around within criminal justice, it seems like somebody would really say, I'm going to get it right. And I heard the supervisor talking about what his hopes and plans and what needs to happen. I also heard Alex talking about it. When we talk about people, not offenders, but people, when we talk about people, and we talk about people with a substance abuse history, why are we talking about chains and cages? Those people with the substance abuse histories are the people that will go to fire camp and fight fires for $1 an hour. Putting their lives on the line at $1 an hour. And when they come home from fire camp, they won't be hired by any fire department. When we talk about nonviolent, non-serious, non-sexual, could we be talking about non-jail? When we talk about people with mental health diagnosis, why are we talking about Twin Towers? Is that a medical facility? A mental health facility? Is it a jail? It's a jail. So something's gone really, really wrong within our society, in our community, when the only resource that we have is a cage. It's chains in a cage. When you think, just think, nonviolent, non-serious, non-jail. And I'm going to end with that.
Thank you, Susan. And I think it's probably a good place to turn the baton over to Reaver Bingham and to have the opportunity to hear about that critical role that probation plays, to get a sense of the lay of the land and the backdrop as we think through the challenges and the types of options that are available for probation, and to think through the new responsibilities of probation under realignment. So thank you, Reaver.
Morning, everyone. I do not have a PowerPoint, but I prefer to speak behind the podium. If I could, it might deflect some of those arrows that might come this way with this target on my back. And I don't know why in the world they would put me behind Susan Burton. I mean, what more can be said? I mean, and after all, I mean, most of the panelists have already spoken to most of the issues. I will speak specifically about what the probation department's role is, and as the other panelists have done, I'd like to thank USCA, the Raven Group, and all those who have put on this seminar and the series of lectures on this topic, and thank you for inviting the probation department to be part of the discussion. I would like to go back. I'll give some numbers later on, but I would like to go back to something the supervisor said earlier. He alluded to the debate that occurred at the onset of public safety realignment regarding who would be the supervision agency, who would take the lead for the implementation of AB 109 in the County of Los Angeles. And yes, it was a very passionate discussion, and yes, the probation department prevailed in that discussion. And I would still hold the position that, yes, the probation department is the most appropriate agency to provide supervision and to take the lead with regards to the implementation of AB 109. With all of the challenges and all of the opinions about the way the legislation was enacted, the way it was thrusted upon the county, with all of the concerns and problems that exist, it's a challenge that the probation department has accepted, that we've embraced, and that over this little over a year and a half, we have dedicated ourselves and committed ourselves to developing the collaborations necessary to roll out public safety realignment. One of the justifications, and you heard it often when the governor would speak and others would speak on the one of the justifications for public safety realignment is that things could be done better at the local level. There were greater opportunities to have a more positive impact on the individuals that we were serving at the local level. There was the thought that things could be done differently, things could be done more efficiently, things could be done more effectively at the local level. And as I indicated, despite all of the opinions about how it came about, we are attempting to embrace the thought that we can do things differently. Just to give you a history, this is not new. Supervision of this population is not a new task for the probation department. There are a lot of things that are new with regards to some of the processes that are necessary under public safety realignment, the way matters get before the court, the funding, those types of things. But in terms of supervising individuals, this is what the probation department has been doing well over 100 years. And just for your information, and Terry talked about those individuals that are eligible under public safety realignment, non-serious, non-violent, non-sexual offenders. The probation department has over 45,000 individuals that are already on probation supervision. 17,000 of those individuals would not have qualified for public safety realignment due to the fact that they are convicted of serious and violent felonies as defined by the penal code. But just to talk about some of the responsibilities under public safety realignment. Some of the things that we've done, and as I survey the room, many of you have already heard some of this with regards to the new responsibilities and some of the things the probation department has done since the implementation of AB 109. But we've developed a pre-release center. The first information that we will get indicating that we're going to be supervising somebody that is eligible for public safety realignment is when we get a packet from CDCR, which goes to our pre-release center. It's at that center, and we've already to date have received over 18,000 packets, and it is at that center that we determine whether or not an individual is eligible for public safety realignment. We look at what conditions of supervision need to be added. We do an initial assessment of what some of the needs are going to be as we start talking about reentry. One of the things that we want to determine is what are some of the needs and services that are going to be needed by an individual once they are released. So that initial assessment is there. We currently have probation staff who work that pre-release center along with a representative from the Department of Mental Health. In the packet, there's some information that might give us a clue that the individual might have mental health needs, and so we will refer that individual or that packet to the Department of Mental Health, who will in turn try to work with the care providers at the state level to get more detailed information so that we can begin a plan of reentry for those persons. We are going to be effective next month, have a representative from the Department of Health Services, because we have recognized the need to transition those individuals that are considered medically fragile or have some type of condition that will require health services as well. To date, we received about 10 individuals that require either skilled nursing facility or some other type of health condition that requires more intrusive care. And so the Department of Health Services will partner with us at the pre-release center. The next thing that we established was the probation hubs. Once an individual is released, they report to our hubs, and it is there where we do the more detailed assessments, and we have the Department of Mental Health, the Department of Public Health, Probation, the Department of Public Social Services, and we're all there working as a team to conduct the necessary assessments to determine what are the needs that this individual may have that will help them successfully reenter the community. And once we all do our assessments, we develop a case plan that's designed to help the person reenter successfully. We also determine what the needs may be. Is there a need for housing? Is there a need for substance abuse, mental health? Is there a need for educational services? Whatever the needs are, employment services, we are developing that case plan at the hub. Then we move them on to our supervision offices, and that's where the case plan that was first of all initiated at the pre-release center, further developed at the hub, will actually be carried out in our supervision offices. And one of the things as well, if you look at our plan, when we first developed the plan for public safety realignment, one of the things that we wanted to do that is considered different, and we've been doing this over about the past 10 years, and you've heard Terri allude to it, and that's the concept of evidence-based practices. We've heard that term thrown about quite a bit. We know it exists in the medical field, and it's been utilized in the criminal justice field for a number of years, but we're looking at what works. What does the scientific evidence suggest will work? What things can we do as a supervision entity that would have the most effective impact on successful reentry with the population? We don't want to take an approach, while we embrace the whole concept of public safety, we believe that public safety also includes the employment of evidence-based practices using cognitive behavioral therapy, and we have probation officers that are being trained in the concept of cognitive behavioral therapy and are actually delivering cognitive behavioral therapy. And we're moving away from a paradigm where we have an individual walk into an area office, we simply give them the rules and regulations and say that if you don't do this, these are the consequences. We are moving away from that model exclusively and embracing the evidence-based practices, where we are looking at how can we help this person think differently so that they react differently to issues and are able to confront the circumstances that may have led them to reincarceration, confront those issues differently and be more successful. So we use risk assessment to target the criminogenic risk factors, and we can talk more about that. I'm going to try to rush and abbreviate this to allow time for your questions. What are some of the things that we are doing to try to ensure individuals are successful on probation? And again, the use of risk and needs assessment, and referring the supervised person to treatment programs. We understand that there is a community of individuals out there that are interested in successful reentry, and we're engaged in the process of building those collaborations, not only with the county agencies, the Department of Mental Health, Public Health, and DPSS, but with the community-based and faith-based organizations out there that are actually your frontline first responders. We work very closely with trying to develop programs that include the larger community. And to that end, by the way, we are in the process of developing a community-based advisory committee, which we hope to have up and running sometime in mid to late July. We hope to have that fully constituted, and we're going to be looking for individuals. We want about a 10 to 12, at max 15-person advisory committee, which will include a PSP, an individual that's the recipient of services, family members, individuals from the community and faith-based organizations to help us think through some of the other issues that are necessary for successful reentry. Some of the other things that we're doing is looking at the manageable caseload sizes, conducting periodic program reviews, and the use of graduated sanctions. Terry talked about the use of flash incarceration. That is one of the items that we use, that's in the menu of services that we use to gain compliance, and I can answer some questions about that as we move forward. One of the things, the concept of split sentencing was discussed earlier. The probation department, our chief probation officer, Jerry Powers, embraces the use of split sentencing, as does the chief probation officers of California. We embrace the concept of split sentences. We have been in conversation with a number of key players within the criminal justice system, including the bench, the DA's office, the public defender. We are having conversations about the expanded use of split sentencing. We don't know exactly where it will go. As it was indicated, in LA County, we use it about 3 to 4% of the cases that have been adjudicated under 1170H. I will just stop there. I do want to recognize, and I didn't do it earlier, we do have our Assistant Chief Probation Officer in the audience, Margarita Perez, to my left, your right there, and I'd like to acknowledge her presence this morning. And I'll stop there and just allow time for Q&A. Let me do this. I'm sorry. I wanted to give you a few numbers. Currently, we have 10,500 individuals that are active on supervision at this time. As I indicated, we've already processed over 18,000 packets, and the supervisor alluded to the way the risk breaks down, and he's absolutely correct. We have 4% of that active population are considered very high risk. That means when we subjected them to our risk tool, they would have scored over 30 on that risk assessment, which classifies them as very high risk for reoffending. The high-risk individuals, there are 56% of those. Medium risk is 38%, and your low risk is about 1%. There are a bunch of other numbers I have here, and I can get, most of you have heard those in other presentations, and I'll just hold them, and you can see me later, and I can share those with you. Thank you.
Thank you, Reaver. I think we've kind of heard the challenge a couple of times now, starting with the supervisor and then from others, including Susan most recently, that we really need to get it right here. And so our next speaker, sort of rounding out this initial dialogue, is Lenore Anderson, who through Californians for Safety and Justice really is trying to figure out, how do we get it right? How do we get it right at the state level, and how do we get it right in local jurisdictions? So we want Lenore to talk a little bit about what is Californians for Safety and Justice, to tell us about the statewide work on justice reform that's been going on post-realignment, and what sort of innovative ideas have been resulting from that statewide work that we can look to try to bring here to our community in Los Angeles, and to get some of Lenore's perceptions of the reform efforts that are afoot here in our backyard. So, Lenore.
This is just a huge opportunity for a really in-depth and robust dialogue. So it's a huge honor for me to be here with this panel, with the supervisor, with USC, and I'm very, very excited and heartened by the conversation and the level of thoughtfulness that we're seeing in LA County as it relates to criminal justice reform. So first, just a word about who Californians for Safety and Justice is. We're a statewide nonprofit organization. We're supported by many philanthropic foundations that have been working on justice reform and issues of health and safety in California for many years. That includes the California Endowment as well as the Ford Foundation and others. And our charge is to advance practices in the justice system that increase public safety and reduce costs at the same time. We do that through a combination of strategies, one of which is policy advocacy at the state level. We're very involved and engaged in conversations about what's next post-realignment in California in terms of justice reform at the state. In addition to that, we work with counties and we offer direct support to counties to advance local innovation and local strategies that increase safety and reduce costs. I'll talk a little bit more about that later. And the third thing we do is we work with victims of crime to advance policies and strategies that meet victims' unmet needs. And one of the things that we talk a little bit about in our work is, we need to improve the justice system, not just because it's been unsustainable for a really long time, but also because many aspects of it have also largely disserved victims, especially victims from high crime communities and underrepresented victims in the conversation around criminal justice. So we're excited about the work we're doing in that area. I want to just do mainly, the main thing I want to focus on are the opportunities and some of the kind of key points that California can take an advantage of, both in LA County and as across the state, to improve the justice system from our perspective. Many of you in the room are experts on some of those areas, and so I'll try and keep my remarks brief so we can have a dialogue about some of them. But before I get into the opportunities, there's a couple of aspects of the how we got here part that I want to highlight, primarily just to add flavor to the conversation, and because it's always important to know kind of where you came from in order to figure out where to go. We talked a lot about some of the challenges in LA County, some of the precursors and things that led to realignment, but there's two things that are always important from our perspective to talk about when we talk about criminal justice. And these are two things that matter, not just in California, but it's actually a part of a national challenge. One is that we got to a corrections crisis, we got to overcrowded prisons by a series of changes in the 80s and into the 90s in terms of sentencing law, right? So it wasn't happenstance. There were some significant changes to how we sentence people in the criminal justice system that drove the number of people going into the justice system up. Right, and this was not, California was not alone in that. In many ways, it was a leader in some of that. But this sort of what's often referred to as the tough on crime sentencing movement in the 80s and 90s in the United States kind of was across the country. There were significant changes that increased the number of felonies, increased the mandatory or fixed terms for felonies, and so very much increasing the length of time people spend in incarceration and the number of people who go in. And so that is a key part of the history in terms of how we got to bloated and overcrowded prisons that then led to the policy change in California called realignment. The question when you look at sort of what happened in terms of the sentencing law changes that then led to overcrowding that has now led to new opportunities for reform, there's two things about the impact of that I want to mention because I think they're relevant for how we plan moving forward. One of them, it's already been mentioned a couple of times, the recidivism rates, right? So those increases in sentences did not necessarily address the cycle of crime or reduce recidivism or work to effectuate increased public safety as it relates to that revolving door as was referred to. So we've spent an enormous amount of time strengthening tough laws with not much of an impact for the majority of people in the system in terms of the cycle of crime. In addition to the recidivism challenge and what that means in terms of what we've seen, there's also the impact on cost, right? California's correction system at the state level, the amount of money spent on corrections increased by 1,500% over a 25-year period, right, from the 80s into the early 2000s, 1,500%, right? Enormous increase in spending that accompanied that significant increase in the number of people going in. Well, so given that we have limited public resources, that's had an impact on public dollars and tax dollars available for strategies that we know also contribute to safe communities, right? So education, college education, early childhood education, preschool, as well as health and violence prevention programs, things like that. So when we talk about, where we're going to go from here, we want to make sure we understand what have been the limitations of the prior strategies in terms of recidivism and stopping the cycle of crime, but then also what's been unsustainable about where we were in terms of what it means in how we spend our public resources. What does that mean? Well, it means when we talk about the opportunity, we really see, realignment is a huge opportunity, right? And we see it as an opportunity because there's a moment in time where we can really set a new safety standard, and we can set a new standard for public safety in LA County and in the state. The scope and scale of LA cannot be understated, right? I do have these conversations across the state in different counties and different parts of regions, and they're talking about a couple hundred people. They're talking about 50 new beds. There's just nothing that compares to LA County. So we don't want to underestimate the challenge, right? I mean, many people said, look, this was enormous. Asking LA County to turn on a dime when it's the largest, local justice system possibly in the world is a pretty high bar. That being said, because it's so huge here, what that means is what LA County does can have an enormous influence, not just on the conversation around criminal justice in California, but from my perspective in the nation. Oftentimes, I talk to people in other parts of the country, they'll say what's going on in California and what's going on in LA, right? Because it's so huge here and it's such a big system. So, so we know that the opportunity in California is really informed by what LA County does. And so setting a new safety standard, we had one, right? We had sort of a punishment, a prison-first approach that was consistent with changes that happened across the country in the 80s and 90s. And we've learned that that's unsustainable and limited in effectiveness. So what do we want besides prison-first and punishment? How can we move forward? Well, one of the things that really rises to the top is something that many of the other panelists have mentioned. What are the strategies that reduce recidivism and stop the cycle of crime? If we look at criminal cases, if we look at individual instances of something that's happened and we have an analysis of how are you going to stop that from happening again, you might draw different conclusions than you would if it was just how to punish the person, right? So we want accountability, we want punishment, there's no question about that. In addition to that, how are we making sure that reducing recidivism, reducing the cycle of crime is part of our analysis about how we hold people accountable. And that, in many ways, could look like a very, very different justice system. And so I want to highlight, 5 changes or 5 things that we're seeing, not just in LA County, but also across the state, that seem to be key decision points, key moments where we're seeing shifts in how criminal justice looks. And then I want to just give a few examples, and then I'll close out so we can get to questions. So first, when we talk about what does smart justice look like, where, how would we change it so that we had strategic use of our criminal justice dollars, emphasizing serious and violent crime, making sure we're using the most expensive end of the system for the people that have committed serious and violent crime, and then getting smart on how we do reform across the board. Pretrial is one thing that comes up a lot. We're seeing a lot of counties, it's interesting, right? Because AB 109 was really about taking people who used to be in state prison and then putting them in the local system. But what has happened is many local systems are starting to reassess, okay, well, who all's in the local system, right? Because we just got additional pressures on the local system. And so it requires that we you can't just say, what are we going to do with people who are AB 109ers? It actually, the moment right now is, what are we going to do with the whole local system? And one of the things that's popping up is we're seeing counties using this opportunity to engage in pretrial reform, right? And what that means is we are looking at models for supervising people in the community prior to their trial. If people are if counties use risk assessment, then they can figure out the dangerousness of the individual. If the person is low risk, they can be supervised in the community at a fraction of the cost, and also make sure that we're freeing up that jail space. So pretrial is one of the trends we're seeing across the state that is relevant in a post-realignment California. The second is, we talk about realignment and why it came about, overcrowded prisons, Supreme Court decision, and then what it does, in terms of the non-9s and whatnot. There's something else that's talked a little bit less about that realignment did, and it set something out called community corrections, right? It said, look, this is now, we're going to have local control. It was, as was mentioned earlier, locals are more in touch with community organizations, have a better opportunity to hold people accountable locally. And it said, we're going to do this through a community corrections partnership. We're going to focus and emphasize and encourage the county system to use community corrections. Well, what that means is, for the majority of people coming in the justice system, what are the non-custodial sanctions that are a partnership between treatment and supervision that can reduce that person's recidivism, right? So we really want to talk a lot about how do we strengthen community corrections as a legitimate part of the criminal justice system. And we're seeing a lot more probation departments in particular play a key role in this. We're seeing a lot more partnership between probation and treatment in different parts of the state. And we're also seeing an increased use of risk assessment to determine how do we match each person on probation with the right kind of programming, right? So that's really what you're looking for when you're looking for models of the best practices in community corrections. So there's pretrial, there's community corrections, which oftentimes involves risk assessment. And then another major area and opportunity for local jurisdictions is something that actually comes out of the healthcare reform world, right? So just at the same time that we've been talking about realignment and this big shift in California, there's another major shift that's coming on board very soon, and that's called the Affordable Care Act. Well, there's this interesting convergence between those two shifts. And here's what it is. The majority of people, I will never forget, I heard the sheriff of Stanislaus County speak one time, and one of the first things he said was 90% of the people in my jail are either addicted to drugs or suffering from mental illness, right? Significant mental health challenges. Where are the health resources? Where is the health system on addressing and dealing with those problems, right? Well, it hasn't been there in large part because many of the people who have been cycling in and out of the justice system with drug addiction or mental health issues haven't been eligible for Medi-Cal, right? These are largely uninsured population. In San Francisco County, the county I've done some work in, 90% of the people in jail are uninsured. I think it's maybe not be that high in LA County, but it's certainly probably the majority of people in the jail system are uninsured. So you have a chronically ill population that's been uninsured, cycling in and out of the justice system for decades, right? This is extremely costly. And now there's a new opportunity to address this, and that's called the Affordable Care Act. One of the main things that the Affordable Care Act did is it said single adults with no children who are below a certain percentage of the poverty rate are now eligible for Medicaid, which in California is called Medi-Cal. So that means all of a sudden, 70, 80, 90% of the people cycling in and out of our jails with chronic illness are eligible for health insurance. So can we get them enrolled, and then can we build out the healthcare systems that we would need to have quality treatment so those people are not cycling in and out of our justice system, but are actually getting into treatment and getting the help that they need to avoid that cycle. And then the last opportunity for reform that I'll mention is something that's been talked about quite a bit, which is reentry, right? We support the notion of split sentencing very much. We definitely agree that we want to set people up to reintegrate productively and effectively, and when we don't do that, we're failing ourselves, we're failing our communities, and we're failing those individuals as well. And so we definitely think that it's the responsibility of all the parties in the criminal justice system to think through effective reentry and invest in quality reentry opportunities. So let's see. I have a bunch of examples I could give of different counties, but I want to be respectful of the time. I also talk really fast, and so maybe I should slow down and see if we should switch to questions and answers, and I can give examples of what other counties are doing. I'll just close by saying, like I said, I think that, however we got here, here we are, right? And it's now up to local jurisdictions, and I think through new partnerships, we do a tremendous amount of outreach to law enforcement. We see law enforcement as key, prosecution offices as key partners in reform, sheriff's departments. These are the moments where, the old way of doing business, which was sort of, law enforcement on one side, advocates on the other, that day is gone. And, I think that we can do that, and I think LA County can be a leader in that. So, thank you.
So I'm actually going to take the prerogative of the moderator to do two things. Not to release you early, so high expectations, but I'm not going to be that generous. First, I am going to ask a couple of follow-up questions in my own right, and hopefully start to generate a little bit of the dialogue. And then the second thing I'm going to do is do away with the index cards. I think I'd like to have a little opportunity for interactive conversation. So if you all promise that what you ask will be questions rather than providing us with your own long views, not that you don't have them and that you aren't expert in your own right, but I think I'd like to get a little bit of the interchange happening. So let me start with perhaps an attempt to maybe figure out what is the crocodile in the bathtub here that's keeping some of these good ideas from moving forward. It's clear, I think, to so many of us that there aren't a shortage of good ideas, and that some of this is not rocket science. We know how to move forward in some better directions. We also know it's not easy to turn a large ship. And so I guess I'd like to ask all of you, and if you don't have views, that's okay, but if you have thoughts on what might be the one or two biggest hurdles that we have to jump over to move forward, whether it might be politics or institutional constraints or attitudinal shifts that we need to bring about, financial resources, or something else completely. So maybe just, Alex, not to put you on the spot, but maybe starting with you, and then, I think, Terry, since you've seen this at both a state and a local level, see if you have thoughts after that.
Well, thank you for putting me on the spot, Miriam.
My pleasure.
Well, I think one of the issues that we confront in terms of a challenge is being stuck in incrementalism. These are serious, these are tough issues, but we have to think broadly. I think we have to be innovative in our approach to solving some of these problems. So I think incrementalism is one of the issues. Also, I think we just need to lay it on the table. Political will is another significant issue, and our policymakers need to have the political will, have the orientation that there needs to be a change in our policies, a change in our approach to public safety. We have the resources. I think it's just the way that we use the resources that is important. We need to be, again, we need to have smart justice. We can't just do the same old things that we've been doing for many years. So I think those three things, incrementalism, political will, and then using our resources in a smart manner are a couple of the ways that we can solve these challenges.
Terry, do you have any thoughts you want to add?
Sure, I would absolutely agree with Alex. I think another major challenge is siloed thinking and competing for resources. We get into a point where we're focusing on ourselves and not synergetically addressing this issue. There's also fear. You know, people, there are elected officials, there are lifetime policymakers, they're afraid of bad outcomes. And every time there's a bad outcome, it's splashed all over the paper, and it freaks people out. And what happens is, if there's not a synergetic approach where we're all sitting side by side at the table saying, this is the right approach. We recognize there are bad outcomes. There are always bad outcomes. In criminal justice, it's the bad outcome business. But what never hits the paper is the thousands of good outcomes, right? And so people get afraid. And a bad outcome happens, and the pendulum swings like never before. I don't know how realignment will end. It'll be interesting to see in 20 years from now how it swung. It swung, Lenore talked about the truth in sentencing laws of the 80s, right? Lock them all down, 3 strikes, build prisons, shove them in there, warehouse them. That's one pendulum. And now here we're at the other pendulum. But if we don't grab arm in arm, shoulder to shoulder to say this is what works, have courageous leadership, have honest discussions about how do we handle the bad outcomes. When the bad outcomes happen, we don't shoot at each other and we don't tremble, and we stand up and say, this is the risk of the business in which we take, and let's focus on the 95% that went well. And I think it requires focus. You know, the best part about realignment really is the fact that a lot of people can now pronounce recidivism. The truth of the matter is the state bureaucrats were the only people ever saying recidivism. And matter of fact, many people can't even say it right. They say revisit them, middle them, and so it's mostly people like Lenore and people like Susan, people like Miriam, people like people in the audience coming forward to people like Reaver and I and saying there are other ways to do business. We're willing to help. Young lady said, we got 100 beds. Will you find some women to put in them? And courageous leadership, not getting where we're infighting. And I think the other things that folks need to realize is that, change has to happen a little bit slower than people would like. Because when you get that bad outcome, if you went too fast, it kills what you're trying to do. And so some understanding by the people that want things to happen so quickly that very robust, energetic approach to it could kill the very thing in which you're trying to accomplish. I think we probably talked for 10 hours about the barriers to it, but those are the ones that come to mind.
I want to maybe, Lenore, both ask you if you have other thoughts, but actually build a little bit on one of the very important points that Terry just made, which is we all know that the high-profile tragic case is out there. It's bound to happen. It may have already happened, but that when it does, there's a rush to show everything that's wrong with some of these bolder approaches. And I guess, given the work that you all are doing to try to raise public awareness, build that deeper understanding, maybe to get your thoughts, Lenore, on how do we inoculate against that inevitable tragedy? How do we try to build, sort of a little bit more resistance to that tragedy that's going to strike that too often then leads to policy making that's reactive and that's that sort of swinging pendulum rather than a steady as we go vision of where we need to go?
Here's a microphone. there's a couple of different things that come to my mind when we think about, what it would take. One is that, I think that in many ways the public is often disserved by an inaccurate discourse on public safety, right? And I think part of what we need to do is give everyday people an opportunity to understand really specifically and clearly what works to keep communities safe and what the opportunities are to change our standards in the justice system. I think that there's still, a very, fear-based dialogue that happens. One of the things that we've seen across the state, is that the initial take on realignment was that it was going to cause huge public safety problems. There's certainly higher standards that we can hold ourselves to in terms of reducing risk and protecting the public, but we also need to move away from hyperbole, right? We really need to have facts drive the conversation and give everyday Californians an understanding of those facts. So we spend a lot of time trying to educate the public on what the facts are in terms of what the challenges were to our prior system and then what the facts are about what's working well. The other thing that I would just mention is that despite this sort of hyperbole and oftentimes fear-based conversation, it's also often kind of a narrow conversation. It's not necessarily engaging a broad scope of the public. And what we've done, we do public opinion polling, we've done outreach, we've done focus groups. We spend time trying to figure out where Californians are at. And what we've found is that it's actually a little bit counterintuitive, right? I think especially today, after the years of a more sort of tough on crime rhetoric, most Californians prefer investments in rehabilitation. They want to see rehabilitation means something to the majority of Californians. They want to see smart justice strategies that increase public safety and reduce costs. We recently did a poll, a survey of victims of crime across California and asked some questions both about what their experiences were as victims, but then also what their take is on some of the public safety priorities the state should be engaged in. And this notion of rehabilitation, supervised probation programs inside jails and prisons that reduce recidivism. Those are the kinds of ideas that really rose to the top, above and beyond, sort of just traditional, punishment-only focused approaches. So, I think we need to pull more people into it. One of the things we do, I mentioned our work with victims of crime. We have a program in our organization called Survivors for Safety and Justice, and one of the focuses there is let's bring people into the conversation who live in impacted communities, who live in communities that deal with high crime, that deal with kind of the constant cycle. And what we found is people in communities who deal with both crime also understand some of the limitations of the incarceration-only approach, and really want to see something that addresses trauma, addresses opportunities for healing, addresses and really invests in prevention. And so I think let's broaden the conversation, let's bring more people into it, let's really get a sense for where Californians are at, and let's move away from fear-based conversations.
Perfect.
Here's some ideas. Oh,
Let me maybe ask one more question and then open it up. A number of you have talked about the issue of split sentences, and I think it's been aptly pointed out that Los Angeles is really kind of off the mark in terms of where the rest of the state is on that issue. And I'm interested to get your thoughts on, it sounds like that is an issue that now there's a coming together around the need to put it on the table, at least, and rethink it. And interested to see whether probation or the sheriff's department or others have thoughts on why we're not, sort of moving forward, or how likely it is that we might see some change come about in terms of LA's ability to rethink that issue.
Not so sure about when the change may occur, but as I indicated, there are conversations that have begun relative to the lack of use of split sentencing in LA County, and we've had many of the decision makers around the table just to speak through and to talk about why that might be so. And there are a number of reasons that have been offered for it. Primarily, I mean, one reason possibly is by the time it gets to a bench officer, there's already been plea negotiations that have taken place that the impacted person, the defendant, may not view the split sentence as something that could potentially be beneficial. We know that individuals calculate the time and they know the benefits, they know the pros and cons, and have made certain determinations, and decisions are made by the time it gets to a bench officer. So there are a number of ways that individual agencies are talking about what the how that might be encouraged or further discussed, but I can just simply say that we're still having that conversations. We see the benefit from a public safety standpoint in that once an individual has served their time in custody, there's an opportunity for them to avail themselves of community-based services, and there's also subsidized community-based services, and there's also an opportunity for the supervision agency to make some determinations about their attitude towards rehabilitation, whether or not some of the programs that they may have availed themselves to in custody have actually begun to be part of their decision-making processes. So it does give us that time to gauge whether or not a person has made a decision to successfully reenter the community and to abandon some of the lifestyle that led to their going to state prison in the first place. So the bottom line is we don't know where the conversations are going. We're having them. Our goal is to see an increased use of split sentence option, but there are a whole host of variables that that contribute to whether or not such a decision is made, and a lot of it has to do with what happens at the plea negotiation stages.
And I know we have representatives from the DA's office here. I don't want to put you on the spot, but if there's any perspective that you want to add, Bill, to the conversation about that? I don't think we have a roving mic, so either if you want to speak loudly, or I think this mic can probably reach you.
I'm used to speaking loudly, so if anyone can't hear me, just let me know. Reaver is entirely correct. There are ongoing conversations with regard to why the relatively low percentage of usage of split sentencing in Los Angeles County. In the last 6 months, I have visited every one of our branch courthouses, every one of our area courthouses, as well as talked to people working in our central trials divisions downtown. I've asked calendar deputies, defense attorneys, judges, supervising judges, and others about split sentences. And this is part of my own quest to better advise our new district attorney, Jackie Lacey, so we can understand what is going on. And for me, it's a question of drilling down to the ground floor, like Reaver was talking about, to understand what is going on. So here are my observations, and I offer these to you only with the caveat that these are observations, not necessarily conclusions. I don't know if the supervisor is still here, but I will be reporting some of these same observations to the LA County Board of Supervisors in about 2 weeks. So here we go. One, the courts, that is our judges, they have no policy against split sentences. And that's what they'll tell you. Reaver and I have heard that in some of the meetings we've been at. Two, the LA County District Attorney's Office does not have a policy against split sentences. So what is going on? What's going on at ground level that's causing this phenomenon of a relatively low usage of split sentences? And I offer the following, and it's confirmed by one of my colleagues here today, Mario Trujillo, who works as a calendar deputy at one of our busy courts. Unfamiliarity by judges. And in fact, in my visits throughout the county, there seems to be, from branch court to branch court, a court culture which exists, sometimes driven by the supervising judge. And quite frankly, in some places I visited, I've been told by the officers, we just don't do that. I'm not quite sure why, but I think part of it has to do with lack of familiarity. Terri McDonald spoke about, the rapidity with which arraignment was, realignment was sort of thrust upon the counties. In other times, given the magnitude of what realignment is all about, you would have preferred, and various agencies and institutions would have preferred, maybe a year and a half ramp up, something so people could calmly contemplate every possible ramification of what such a sea change in criminal justice was going to occur. We didn't have the benefit of that in our various California counties. It came upon us, and to some degree, we're still reacting. So, in part, I would say it's lack of familiarity by members of the system, including the bench. Secondly, as Reaver suggested, and we've been privy to the same conversations, several of our, a percentage of our defendants don't want anything to do with anything that has a supervision tail. So they hear split sentence, I do so much time in custody, and then I've got so much time where I'm going to be subject to mandatory supervision. At a street level, at a street savvy level, various defendants are saying, you know what, I'd rather eat a little more jail time. Maybe I'll only do a percentage of what I'm sentenced to because of jail overcrowding. And then I can hit the street and I have no supervision tail, as they call it. I'm not subject to search and seizure provisions. I'd rather be unsupervised when I get back out in the street. And I'm hearing some nods of affirmation here. So I think those are two dynamics, really lack of familiarity by participants. Secondly, our defendants, some of our defendants want nothing to do with it. There is a subset of our incarcerated population who is very much interested in mandatory supervision. There was a slide that was on the screen about we have quite a few inmates in our county jail right now who have sentences over 10 years. Over 10 years in county jail. This is something our jails are really not built for. Well, we looked into what are those cases. We pulled the files. What are those cases? A very large percentage of them come from our major narcotics division. Major narcotics traffickers who deal with large quantities of controlled substances were subject to weight enhancements or quantity enhancements which drive up their potential sentences, have found mandatory supervision to actually be conducive for their sentencing purposes in this regard. They'll get, they will plead open to the court, so there's the DA, even when we object that this is what the court is doing. They'll plead open to the court, they'll get, or using round numbers, a 30-year sentence. And the judge will say, 10 years of that you're going to do in custody. Well, automatically, if they were in prison, they do half time, so that's reduced to 5 years. And the judge will say, I'm giving you 20 years of mandatory supervision. This is what some of our lengthy jail sentences are that have been reported. And for some of our major narcotics traffickers, usually represented by private counsel who are skilled and paid well to get the best deal for their major narcotics defendants, this is a phenomenon that's going on. So, Miriam, those are the best observations I can offer at this point.
Thank you, very helpful. So let me open it up for questions.
I just wanted to make a comment in
yes,
regards
sorry,
to
I'm sorry.
the district attorney's offices and my experience with the criminal justice system and the district attorney's office. My experience has always been that the district attorney's office holds all of the power through the court system, and the district attorney has the ability to charge or not charge and to say what you're going to be charged with. Also has the power to offer treatment or not treatment, and in this case has the power power to offer split sentencing or not split sentencing. Also has the power to make it sweet enough that whatever you want to see the outcome is, that's what the outcome is going to be. And so I don't understand why only 5% of people in LA County are getting split sentencing, and where in other parts it's up to 50, 60, 70% of people courts are using split sentencing. So I don't know what's going on, but from my experience, the district attorney offices holds all the power in plea deals and court deals. It doesn't matter, whether or not you're innocent, whether or not you're guilty. When the district attorney steps up and says, you get 3 years if you plead, you get 1 year or 2 years, or you get 30 years if you don't plead and you go to trial. So, I mean, there's just something that I'm not hearing that's a little, balanced or right about that. And I just, as a person going through the criminal justice system and a person dealing with people in the criminal justice system that has just left the criminal justice system, I just see something's really wrong. One woman, I wanna just hold her up. She had 0.04 grams of cocaine or crack and came home after doing a 5-year sentence. That was the power of the DA. She could have been leaving Yale or Harvard or USC with a law degree probably, but what she came home was with under supervision of probation and the PRCS program. So I just needed to jump in there and talk about the experience in the criminal justice system with the district attorneys.
Did you want, yes, and then we'll start to move around the room. Yes, sir.
My name is Maya Video, I'm Deputy District Attorney. The DA's office, as well as the judges, what we find is we're very reactionary to what the legislature puts in front of us. We're the enforcement part of the criminal justice system. The penal code is basically our guide. Our DAs are trained anytime they're presenting an offer to follow the penal code. The word diversion has come up a couple of times. Well, the penal code only uses diversion in the PC 1000 statutes. We're waiting for the legislature to give us the power, to give the judges the power to really divert people from the system. It has to be in the penal code. I look at the judges every time they're about to sentence someone, and what do they whip out? The penal code. I would suggest that we put split sentencing as an alternative in every punishment scheme. Community-based alternative sentencing programs. The judges, when they see those words in black and white that the legislature has told them it's okay, Mr. or Mrs. Judge, to put this person in a community-based rehabilitation program, they will be empowered to do that. The DA's office, we enforce the laws that the people, through their representatives, the people we elect to the assembly, give us. The DA does not write the law. We have to work in partnership with the legislature. We need to be going to Sacramento much more often to say, we need all these things to be written in the penal code so that the DAs, I agree with you, and the judges will have the power to do it.
Well, thank you for that. And let me maybe offer a thought, and then we'll start to move around the room with some more of your questions. I think one thing we heard from Lenore is the efforts of CSJ to bring constituencies together and to bring voices together. And I really think what we're hearing here is kind of a convergence of interests, among those who have been in custody or have had loved ones either in custody or victims of crime, and those involved in law enforcement. And I think this conversation really underscores the value of all of us working together to not simply be, sort of smart on crime and smart on justice reform, but smart on how we get there and how we kind of work together to bring about some of these changes. And I do think that law enforcement can be a very powerful force in partnership with the community, with the victims, with these other voices in trying to turn the corner. So I think that's, a wonderful observation that there might be some intersection of interests here that we could work on together. So let me, the woman in the second row, yes.
Thank you. My name is Lynn Lyman with the Drug Policy Alliance and the Los Angeles Regional Reentry Partnership. And I first want to just thank the panel. This is a great panel. Many of the representatives of the government on this panel are the very ones who do answer their phones, do respond to their emails. So although we might not always agree, Reaver always responds when I call him.
He may now be changing his phone number, but somebody will recover.
But what I think is instructive is who's not in this room from our elected governments, right? So I think it's very important to note that Mark Ridley-Thomas is the only supervisor's office who's present, and that the 3 agencies are the only ones who are present. So let's just note that. I have several points I want to make in response to your question, Miriam, but I promise I'll end with a question.
Okay, well, I'm going to give you, 10 seconds for your points, and then you...
So I just want to say that in terms of what are the hurdles to why this isn't working, there are clearly political hurdles. Some of those we have to wait for the electoral system to take effect in 2014 to change, meaning when term limits come into effect for the Board of Supervisors for the first time. That is when we will begin to have more than 1 vote, sometimes 2 votes on the Board of Supervisors. Unfortunately, you usually need 3. But there's some structural changes that we can do something about right now that we haven't done something about. I'm going to mention 3 issues that I think each of our representing entities here has a responsible role in. One is the supervisor talked about reentry. Where's the space for reentry? Well, one of the most important things for reentry, as everybody in this room knows, is employment. We know that reduces recidivism, right? We all know that we all work in this field. Well, there's a bill that has come up again and again and is up right now, Bill AB 218, to ban the box. And our county board of supervisors formally opposes that bill. Now, Mark Ridley-Thomas is excused. He was the 1 vote that couldn't do this. But let me just say that we have a county that is representing, the largest county in the state is representing to the state officials that they do not want to ban the box. That is a problem. Number 2, people who are coming out of incarceration need a place to live, they need food, they need services. Right now, and as we know, most of what's driving the population in prisons are drug crimes, right? Drug offenses. And right now, if you've ever been convicted of a drug felony, you are banned for life from receiving public benefits, in particular food stamps. SB 283, again, is a bill that would eliminate the ban on food stamps. The District Attorneys Association of California has opposed that. The Sheriff's Association of California has opposed that. The Police Chiefs Association of California has opposed that. And then lastly, we also know, so because we can't change these issues, or so it seems so hard to change these extra punishments, what we're trying to do is change the sentencing laws. One of the laws we're trying to change is that if you're convicted of simple possession, it should not, of a drug, of illicit substance, it should not be an automatic felony. So you then aren't banned from all of these other services. SB 649 by Mark Leno is one of the bills we're working on that would give prosecutors the discretion to charge simple drug possession as a felony or a misdemeanor. Unfortunately, the prosecutors oppose that. Again, why they oppose giving themselves discretion is really beyond my understanding, as do the sheriffs are also opposing that. So while this is not individual LA District Attorney's Office or LA Sheriff, the associations that represent them in Sacramento are working against our will. For my question.
And I'm going to be more strict on the rest of you. So it only takes 1 student to go off the reservation.
I'm glad I discussed that because I think there's a lot of information that isn't enough, but that's important. Or the fact that the contract for the community reentry services that Susan Burton and many folks in here are providing is only allotted every 90 days.
So the question,
every 90 days, and nobody can run a 90-day business. So the question is, in addition to all of this, what hasn't come up today is the Prop 36, the recent Prop 36 3 strikes reform. We have 1,100 individuals that are eligible for release under 3 strikes reform. What we are asking from the community to the representatives of the Board of Supervisors, unfortunately there's only 1 here, and to the 2 members of the PSRT from Sheriff and Probation, is to consider allowing AB 109 funds to be used to cover reentry services for the 1,100 third strikers that will be getting out in Los Angeles. That's my question.
Okay, so let me actually maybe expand that question a little bit. So I think that there were a few things raised in that, and again, I am going to don't make me, regret the elimination of the index cards, and they'll never ask me to moderate anything again. So I think we've heard about 3 legislative initiatives: AB 218, AB 283. SB 649, and we've heard about the Prop 36 issues. And I guess I'd like to ask, maybe again, Alex, putting you on the spot first, what your thoughts are as to where the board ended up coming out or where it didn't have the votes to come out on those issues, and whether you have any sort of perspectives on how one can, despite that, be able to get LA's voice into the mix in trying to achieve some of those reforms, and then seeing if any of our other panelists have thoughts on any of those issues.
All right. Well, I think Lynn hit the points accurately in terms of the sea change that will perhaps need to take place on the board come 2014, given that there are 3 votes that are needed in order to pass most policy, most legislation on the board. But I think she hit one important point that I just must reinforce again, which is the issue of reentry. The VERA report, I think that was March or February, highlighted that the issue of employment and housing were the top 2 issues facing individuals who were returning home. And so a part of the issue with the county is we don't know where, whether it's AB 109 resources or other resources, where all the dollars are going to in terms of reentry services. We know that we need reentry. We know that rehabilitation and reentry are important. We know that reintegration is important. We know that placing people back on a pathway to improve the quality of their lives is important. But we don't, I think, and Terri McDonald has highlighted this, we have silos. We don't, I think, know where we are investing our resources. I think more attention needs to be focused on that aspect in terms of the reentry agenda. But there are some effective strategies that are going on in terms of reentry. Susan, I think, can talk to the family reunification piece that A New Way of Life is doing, that the county is working on. Our office is working on the issue of providing individuals with identification, which is a tool that is definitely needed to ensure that they are placed back on a pathway to success. So I just want to highlight those points with respect to reentry. In terms of ban the box, yes, supervisors on record as that being another tool of the reentry agenda to give individuals a chance to be hired. Just give them a chance. And the county policy, again, this is an issue of votes, issue of political will, issue of orientation, and understanding of the significance of these problems. I am not sure what we do right now. I can be perfectly honest with you. I think we need advocates to continue to drumbeat, to continue to push for change, to show up at the Board of Supervisors meetings and testify and speak to these issues. I think we have to have sustained advocacy. We cannot let go. We need to keep our feet planted on the ground. We need to keep fighting, keep marching, keep pushing to cause our policymakers to understand what is right and what needs to be done. So those are my perspectives on that. I know our other panelists may have some other things that they would like to share on that, but those are my perspectives on that question.
Okay. See if any of our other panelists want to weigh in with their thoughts. Or Terri, do you know if the sheriff has taken a position on those different measures that were proposals that are out there?
I don't know if the sheriff has or hasn't. The interesting thing about Sheriff Baca is that the Sheriff's Association may go one direction on an issue, and he really pretty much stands alone and a very integrative, progressive thinker on these issues. I mean, the truth of the matter is, within a year of release, 50% of the people come back. And the barriers to successful integration are substance abuse, mental health, housing. There's no secret to this. It's been interesting. Some states like Texas, for example, Texas is a very, very conservative state. They implemented what is called the right on crime approach towards prison management. And it was using a business model to figure out what dollars invested actually saved on incarceration costs. I've read studies where $1 spent on rehabilitation saves you $2 in the criminal justice system, whether it's the courts or public defenders, district attorneys, or beds. And so I think it's long overdue for policymakers to make those kind of approaches. New York, for example, eradicated tough-on sentencing laws that came about in the 80s. And instead of putting everybody in custody, they put them in drug treatment on the front end. And so I agree with Alex that a sustained drumbeat of breaking down assumptions. 3 strikes was a pretty good move by the people of California to say this may not have been the best public policy. I'll tell you, though, to be honest with you, when LA County's been on the leading edge of looking at 3-strike offenders, and in my old role, I was asked to look at, I forget how many, a dozen females who had been in custody for a while and over 10 years. And about half of those 3 strikers were still engaged in significant misconduct in custody. So just because it looks like 1,100 may be eligible, just based on that very unscientific review, there are some people who continue to engage in significant challenges in custody. Doesn't mean that they don't need treatment, doesn't mean they don't need rehab, I'm not saying that. But I wouldn't want you to think that everybody was just quietly doing their time in the system.
Let me perhaps move to the gentleman and then the woman in the front row, and then we'll try to take it.
George Rossetti, Director of Policy at Congress of Racial Equality of California. We don't take funding from anybody, first of all, so we get to call our shots straight.
And sir, I am going to ask you to pose a question, just in the interest of time.
I have to say something else. No one here has addressed what's causing this problem, and that's K through 12. Ask Sheriff Bob.
Yeah.
Okay? So until you deal with, and I'm going to use LA Unified as an example. 2001-2, with 80,000 more enrollment than LA Unified has today, they had only 14,500 not coming to school. When Monica Garcia takes over as board president, Cortines comes in, it's 40,000. Last year it was 117,000 plus. Now where are they? They're on the street, which means they're going to youth authority. Later they're coming to you guys. And nobody's talking about that. Now, I'm sorry, somebody's going to have to get down on the core problem here, and it has to be said.
So let me maybe build on that. I think that's an excellent point. So certainly, we heard how high the juvenile numbers are in our system, in our under probation coming into custody. We know the data on school to prison pipeline. We've seen report after report on that issue. We know that over half of suspensions and expulsions in the state are due to willful defiance, which is very vaguely defined as simply being an adolescent. LA Unified recently took action to move away from that as a basis for suspension and expulsion. But Alex, you're also the supervisor's education deputy. I know you feel like you're being put on the hot seat time after time, and I fully expect you will never sit on a panel I moderate again. But give us some thoughts on, and perhaps Lenore has some thoughts as well, on how do we really kind of scroll back and start to address this school to prison pipeline concern?
I think the gentleman's point is spot on. I think when we talk about our criminal justice policies, when we talk about public safety, we need to expand our thinking. We really need to talk about the continuum, the predicate factors that lead to individuals winding up in the juvenile institutions, that lead to individuals winding up in the county jails and winding up in state prisons. And so it's really, I think Lenore and Terri and others have raised the issue about expanding the tent, expanding the number of individuals who are our justice partners. It can't just be traditional law enforcement partners. It can't just be traditional justice partners. We need to look at our schools, our LAUSD. We need to look at First 5 LA, LA Up, those entities that are impacting the children. So when we look at third grade reading levels, those are indicators of whether or not an individual kid is going to end up in the criminal justice system. And so the issue of school suspensions and otherwise, we need to start early. We cannot just start our intervention, invest our resources on the back end. We can't start when kids are just in the juvenile justice system. We can't start when folks have reached the age of adulthood and are in our county jail. So we need to start on the front end. And again, it's about how we smartly allocate our resources, the attention that we put. It's about advocacy again. And I think that point of interacting with LAUSD, interacting with the state is important. And so I fully agree. I hope that provides some answer to your question.
We have educational realignment coming down from Torres's chief aide also.
Okay, sir, thank you. I think, Reaver, I know that you have some thoughts, and then I'll turn it over to Lenore.
Right. I just wanted to speak to the fact that, I mean, I would agree with everything Alex said, and many of the programs that he communicated, the probation department is engaged in. But I'd like to scale it back even further, if I could, at the risk of being somewhat provocative. We talk about the systems that need to be engaged, but one of the things that we try to talk about heavily is parent empowerment. And we talk about the school system. We talk about what probation needs to do. We talk about what all these programs need to do. And I agree, there's a role for all of them. But I'd like to see us scale back and look at how we can empower parents to make better decisions for their children, how to help them avail themselves of the resources that are in the community. We're in the process of developing day reporting centers. We're involved in 236 at-risk kids. We have diversion programs. We run the gamut. We're looking at disproportionate minority contact. We look at many of the comprehensive education schools that will not accept probation kids back in the school. We've been advocating for that and have made some inroads into that. But one of the main things we think is germane to this discussion is how we work with parents and how we engage the parents and how we have parents embrace their responsibility and not become dependent on a system.
Perfect. Lenore?
I think, fundamentally, we need a new paradigm for public safety that is inclusive of how well we're doing in terms of education, how well we're doing in terms of health. We need new indicators, right? For a long time, the conversation around public safety is very specifically focused on things you can count in the criminal justice system, and those aren't the indicators that are going to lead us to a sustainable path for public safety moving forward, right? So one of the things we've been working on is trying to figure out how would you list out the indicators that matter in terms of identifying whether or not we have a coherent infrastructure for community safety, right? So what are the things you would need to know that you have a good infrastructure in place for community safety, right? Well, some of the things that you would probably look at are, things like what are the chronic absenteeism issues, right? What is the exposure to community violence that children experience? Things like that are indicators that we know. I mean, it's pretty well understood, right, that if you experience those kinds of adverse childhood experiences, your chances of falling through the cracks, whether it be through the justice system or experiencing chronic health problems, are much greater, right? So if we understood community safety to be broader than just what we're doing in our criminal justice system, then we would definitely be investing differently, right? It's interesting, some of the things that, the school-based health centers model, this is where you put a health center inside a school. Well, not only does that improve the health rates for those children, and in some jurisdictions, the parents are also allowed to use that health center. So not only does it improve health, reduces suspension, right? Reduces expulsion, reduces violence on the campus. So there are solutions that are independent of just the narrow focus of our criminal justice system that can help pave a pathway for safety. That we can tell that story to the public. We can share that kind of information about what makes us safe, and we would have different indicators. So so I think that that's part of what building a community safety system looks like.
And let me just punctuate that point by saying one of the biggest pieces of the school-based health centers is the issue of mental health. And those school-based health centers help to correct, to diagnose, to treat the mental health issues that many of these kids come with. I was at a presentation the other day. Our office is doing a gang intervention project with the Advancement Project, and an individual from the LAPD put up a map, and this map showed all the gang lines that kids had to cross to just literally to get from here to that window to go to school, how they had to navigate and negotiate this space, and to have a kid come to school and their mind is focused on the fact that, man, I've got to go through this to get to school, thinking about it, how am I going to get back home? Who's going to try and test me on my way back home? That issue of mental health, that issue of environmental factors that are hurting our kids has to be addressed. And so I think, to Lenore's point, these school-based health centers are tremendously important because of not only addressing the health factors, but also addressing more specifically the mental health issues that many of these kids come with, and which leads them to, in many instances, juvenile justice and issues, school suspensions, willful defiance, et cetera. So.
And let me also note that for those of you who are engaging in these issues, that I think this perfect topic is particularly acute in the wake of Newtown. And there is now a laser focus on how to make schools, quote unquote, safe. And I think that as policy choices are being made, we have to be very cautious about not going into the red zone on what is a safe school and creating fortresses that destroy a positive and supportive school climate. So as choices are being made about, do we invest in more school resource officers, or do we invest in more school counselors and mental health supports and services? I think there's some voices in this room that can be very impactful as those decisions and choices are being made. Yes, the woman in the front row, and then we'll go to the gentleman over there, and then over here.
I'm wondering, in the overall picture of nonviolent individuals being in the release program, where the individuals that are nonviolent yet criminally active in other areas, where they fit, like what kind of accountability or rehabilitation what part of the spectrum do they fit into? Like financial predators, petty thieves, scam artists.
Great question. So maybe Terri,
do we take them off the streets, or do we let them come back out and keep rehabilitating?
So Terri or Reaver, thoughts on that?
So,
See, Alex, you didn't have to go first this time.
So much of the type of crimes that you're talking about are substance abuse driven type crimes, burglary, property crimes. They almost always can be go back towards substance abuse. The highest recidivism crime in California. You might think it's a violent offender. You might think it's a drug addict. It is not. It's a car thief. A car thief is the highest recidivant. They are taken off the streets, but they're not necessarily taken off the streets for an extended period. And if they're taken off the streets and we don't address their core criminogenic needs, they go back out. There are folks that say realignment has led to an increase in property crime, and property crime is up throughout California. I don't know if that's true or not. Violent crime, and whether or not it's realignment. Violent crime's down. So did realignment actually solve violent crime and created property crime? I don't know the answer to that question. But it's these kind of non-serious, non-violent, non-sexual predators that Reaver and we are challenged with dealing with, and they are complex. And citizens have a right to be protected from those type of crimes.
Is there any plan in place from anyone that can create some type of rehabilitation program?
Well, we do have rehabilitation programs for all of the individuals that we're tasked with supervising. As Terri indicated, what we first do is subject them to a risk and needs assessment, and that risk and needs assessment will break out the criminogenic risk factors that needs to be targeted. Now, you can do a risk assessment, but if you don't have the services that are necessary to target that risk assessment, then the risk assessment does nothing but provide you information. So we have, we add conditions and we make certain types of programs consistent with that criminogenic risk factor mandatory for their supervision. So they have to do certain things. And if they do not do those things, if they're not participating in whatever the program is to address their particular issue, there are graduated sanctions that we utilize. Those graduated sanctions could be anything from a verbal admonishment to flash incarceration up to revocation of their supervision. So yes, there are programs targeted
to deal with it.
Thank you. In LA County as well, the jail system has about 40% of the offenders are in the education-based incarceration program, and that's a misnomer. You probably think everybody's in education. They're not. They're in cognitive-based, they're in substance abuse, they're in parenting, they're in life skills. But certainly I'd like to see 90% of them involved in programming.
Okay. Yes, the gentleman on the aisle. Oh, I'm sorry. Actually, the gentleman on the aisle here, sir, and then we'll go back to you in the back after that. But, sir, yes.
My name is Ray Regalado. I'm with the Los Angeles County Human Relations Commission, and we've done a lot of work in the Harvard Gateway area. And I'd like to talk a little bit about the investment in communities, or maybe the redistribution of resources. I think I've heard it a few times where resources aren't necessarily getting to some of those programs that might be able to do some real community-based effort. I'd like to hear some of your views on how we might be able to be a little bit more strategic with how some of these resources go about being distributed.
Yeah. Susan wants to know how to get the resources to distribute. So if there are any large checkbooks in the room, yeah.
Yeah, I'll take an initial stab at it just to kind of let you know how the process works in terms of the distribution of funds. When public safety realignment was enacted and we knew what the allocation would be from the state, all of the departments made their pitch for what they thought they would need for public safety realignment. We also included in that allocation contracts for services that included housing services, transportation, employment services, mental health, substance abuse. I think it was upwards, when you put all that together, there was about $30 million, I think, that was set aside for services. In terms of how that gets into the community, the piece that the probation department has, we have $12 million that's dedicated for housing, employment, transportation, and systems navigation. We have a contract that allows for the management of those services, and that's done through subcontracting them out to other individuals. So that money is dispersed to the community through subcontracting with this one entity. The mental health and public health releases RFPs for services as well. So you have other providers who can qualify for those contracts, who ultimately are the recipients of resources to conduct services as well. And that's sort of the way it's done. And we do this periodically. And again, it's all of the impacted agencies, and the chief executive officer controls the purse strings and ultimately makes the recommendation to the board of supervisors.
Terrific. Gentleman in the back.
Yes, I have a two-part real quick question. There's a conversation and a push to repeal AB 109 and place fear in the community. Is this bill the law, or could it be overturned, and if so, how? The other part of my question is, if a new way of life reentry project is working, then why can't the county, particularly probation department, release some of the balance from last year's funding for services, the 12 million, increase that amount, to provide more programs like a new way of life reentry, and also take in men. Did you answer that question?
Good question. So let's maybe start with repeal of 109. Any thoughts on that? Yeah.
Take that. There's a variety of bills that have been passing through the Assembly and the Senate, changing, either repealing AB 109 in totality or changing aspects of AB 109. And I could go on for an hour on what those are. Every single one of them has been killed in committee. So I think because you've got the United States Supreme Court order hanging over the head of the state prison system with a 13,000 inmate gap, I don't think anybody has any stomach at this point to repeal I don't say anybody. I don't think the majority have the stomach to repeal aspects, but there have been attempts to change it that have failed so far.
Two bills are still out.
And so let me then move to the excellent second part of that, which is that all-important resource issue. And I think Supervisor Ridley-Thomas even sort of referenced it in his remarks at the outset, that we know the strategies and some of the programs that work. Why aren't we adequately resourcing them, and how do we think about perhaps shifting our priorities and finding ways to fund those approaches that are effective? And Alex, I didn't even have to call on you. You're already reaching for the microphone.
Thank you, Miriam. There are finite resources, and as others have indicated, there is a competition for those resources. And so again, it goes back to investing wisely, investing smartly. I will say this, one of the things that our office and the county currently is doing is looking at different models. So one model in particular is social impact bonds, or pay for success models, which have been used in other jurisdictions, in Boston, in New York, essentially leveraging philanthropy, leveraging private dollars to complement the finite public dollars that are available in order to deliver services. And so one example is a partnership that the county is exploring with the Sheriff's Department to provide about 300 beds for individuals who have been identified as homeless, who are AB 109 affiliated. And so that's just one example of the types of creative, innovative ideas that there need to be more of. There is a lot of work being done on the social impact bond. It took a lot of work to get to that point, but I think there's opportunity to do more. We have to do more because of the need that is prevalent, and has to involve community organizations. Susan is kick it back to her, is going to talk about another partnership that she's doing on that also responds to the gentleman in the back in terms of working with males with her organization, but a family reunification project, again, using the dollars that we have wisely, but partnering with other agencies. In this instance, it's the Housing Authority for the City of LA to reunify families. So I'll let Susan hear a little bit about what she's doing with that.
I can nicely get it.
I just wanted to highlight the fact that, again, public safety realignment is still in the process of evolving. It's not a done deal. And when we start, over the last year and a half, we've learned quite a bit. I mean, this is a major paradigm shift. And one of the things that it has done, and we can see it in this room, has brought a lot of people together that are concerned about how we care for individuals and individuals that are returning to our community, our people, our folks. How are they returning to the community? How are we caring for them? How are we providing services to them? It's also brought the county family together in a way that while we had done projects together before, this has brought us together in a way that's unlike anything that we've ever experienced. The community and faith-based organizations, the dialogue and relationships have become a lot more synergistic. And I say all of that just to simply say that, yes, we continue to look at programs such as a New Way of Life. We look at all sorts of programs with a view towards trying to understand what has worked over this a year and a half. We still have a long ways to go. It's not a done deal. There's nothing that's written in stone. We are considering the ways that the resources could be used in a more efficient manner. So I would continue to beseech your patience as we move along. It may seem like a long time, but again, this is one of the most impactful paradigm shifts and corrections in over 30 years. So we're not going to be able to have it exactly right in a year and a half. So if you just continue to be patient with us as we roll it out, we're looking at we want this to work just as much as all of you do.
Thank you. Well, I know that there are more questions, and I apologize for the fact that our time is limited. I will promise that our panelists will stay around afterwards for those of you that do have more questions and want to come up and chat with them. I want to thank our terrific panelists for really a phenomenal conversation. I want to thank all of you for staying, and I guess I want to make two very quick parting observations. The first is, I think we can all agree that realignment is here to stay. So rather than trying to stop the train, I think we need to figure out ways to get on it and move it to the right place. And I think we also need to ensure that we don't let the perfect be the enemy of the good, that there are 1,000 ways to kill innovation. Let's find ways to say yes rather than no, and to work together, all of us, to make these new ideas and new approaches take hold. So thank you all for your interest, for the work that you do, and we look forward to continuing the conversation with you in the months and years to come.